Clear? So it has become almost cliche to say that no crime is constituted unless there is a concurrence of the mens rea with the actus rea, right? And this legal expression, this legal maxim has been expressed in the following terms, that actus non facet reum nisi mensit rea. Mensit rea means no act is guilty unless the mind is also unless the mind of is also guilty. Lord Arabinger, the famous judge, in his judgment in R. Rex versus Alday in 1837 had this to say, that it is a maxim older than the law of England that no man is guilty unless his mind is also guilty. So in order to constitute a crime, these two elements are necessary, mens rea and actus rea. Mens rea is evil intention with which a crime is committed, or the knowledge of the wrongfulness of the act. Right? This is called mens rea. And actus rea means the act itself, the guilty act. So there must be a tainted mind in order for a guilty act to come about. Without tainted mind, without guilty mind, the actus is never vitiated. The act is never vitiated. This is the general principle of crime, right? So this concurrence of these two elements, mens rea and actus rea, is the most necessary concept in the criminal law. And the Ventus type cases which we can refer to in this behalf are R versus Prince of 1875, Quinn versus Tolson of 1889, Tiras versus Tiruzen of 1895. These three cases you can refer to as local classicus on the concept of mens rea. The concept of mens rea and its application or exclusion. The mind must be guilty in order for the act to be characterized as a criminal act. In R versus Prince, to tell you the briefest story, Henry Prince was prosecuted and punished for having committed the crime of abducting a girl below 16 years of age, which was an offense in England at that time. So the law was, if any person takes away a girl child below the age of 16 years without the consent of her father, then that would be a crime, and for which Henry Prince was prosecuted and finally punished. He took the plea at the court, at the trial court, that he had inquired the girl, Annie Phillips, and she had told him that she was of 18 years of age, and he, having believed her to be true, took her away in his company. So he was not guilty as such, because he didn't have guilty mind at that time when he was committing the act. The court rejected this argument, saying that though mens rea happens to be an important component of the crime, true, but it is not applicable in strict liability offenses. When the statute or the law creating the crime doesn't in so many terms mention about the requirement of the mens rea, the courts are not duty bound to read the requirement of mens rea in a law. If the requirement of guilty mind is not mentioned in the law, then courts, while interpreting it or while applying it, are not duty bound to read the requirement of mens rea into that law. And because the law related to abduction of a girl child didn't require mens rea to be a constituent element of the crime, therefore Henry Prince cannot be allowed to take this defense that he didn't have a guilty mind, because that was his strict liability he should have adhered to. When he was taking away that girl, he should have known that he is taking risk. He may be of less than 16 years of age. He was committing a moral act. It was a strict liability offense. So here the plea of mens rea won't be allowed to be heard. This was the decision of the court in that case, and the appellate court also upheld the conviction entered by the trial court in that behalf. Only Justice Brett was of the dissenting opinion, and he said that mens rea is an essential requirement in every crime. Without proving the element of mens rea, no crime can be convicted, no crime can be said to have been committed. So, it is a misconception to say that R versus Prince is not emphatic about the requirement of mens rea in a crime. In fact, it is emphatic. The judges have done a very good work there, and they have said that so far as abduction of a child or kidnapping of a child below the age of 16 years is concerned, that is a kind of a strict liability offense. And before we arrive at a conclusion that whether it is a strict liability offense or whether the requirement of mens rea has to be read into it, one will have to cast a look at several considerations, several factors, like among which section this offense is situated. If all the neighborhood provisions of the law are related to strict liability offenses, then if this provision is there in the law creating a strict liability, then so be it. If the purpose or the object of the act is such that if a strict liability is not read into the law, then the object will get defeated. The object of the law will get defeated. Therefore, in order to arrive at a conclusion whether mens rea is required in that crime or not, we will have to take into consideration not only the text of the law, but also several other considerations like the purpose and object of the act, like the group in which the section is situated, etc. Right. Furthermore, in Quinn versus Tolson, what was the case like? In Quinn versus Tolson, Tolson was the previous husband of the accused wife, and the wife, believing her husband Mr. Tolson to be dead within 7 years of the marriage with Mr. Tolson, she entered into a second marriage, or she entered into a remarriage, and for that she was prosecuted for the offense of bigamy, and she was sought to be convicted at the trial court. When she took the plea there, that she was not having the guilty intention as she entered into her second marriage with another person, because she had made sufficient inquiry, and based on reasonable grounds, she believed that her previous husband Mr. Tolson, her existing husband Mr. Tolson, was dead because he was on board a vessel bound for America which had run aground, and all the persons on board the ship had expired. And so after having satisfied herself about the truthfulness of this news, she decided to enter into a marriage another time, second time, and so she didn't commit any wrongful act because she wasn't having any mens rea as such. But this plea was rejected by the trial court. She appealed, and finally the matter came to the appellate court, and the appellate court said that R versus Prince was a distinguishable case from this one. In R versus Prince, what had happened, that Mr. Prince himself was guilty. He was doing an immoral act. He should have known that this is one strict liability offense. But here, bigamy related law is not free of the requirement of mens rea. If the lady was not having a guilty mind, she could not be said to have committed the act with a guilty intention here, because she had made inquiry. She acted in good faith, and that's why she cannot be attributed with the requisite mens rea, and she was finally acquitted in this case. So far as Serras versus DeRozan is concerned, here a hotelier, a shop owner was sought to be convicted for supplying liquor to a police officer on duty. That police officer was not wearing any badge or not wearing any symbol on the basis of which he could be identified. But here also it was found that because the prisoner, the accused, was not having the sufficient mens rea, therefore he cannot be convicted of the offence. Justice Wright, writing his judgment, said that the requirement of mens rea is an inherent element in every crime, but that requirement can be dispensed with by the terms of the law itself or by necessary implication. If the object of the law is such that if requirement of mens rea is incorporated into it, then the object, the very purpose of the law is bound to be defeated, in which case it may be inferred by the court that mens rea is not an essential requirement for this type of a crime. So, this principle of law, which has been applied in these classical cases, have been followed all around the world, and in our country also several cases have been there at the Supreme Court. They have been argued at the bar, and requirement of mens rea has been read into our law sufficiently, though our law, be it IPC or any other law like BNS, the requirement of mens rea has been taken care of by the mention of certain acts like dishonestly, voluntarily, reason to believe, fraudulently. These kind of words sufficiently indicate the element or requirement of mens rea before a person can be said to have committed a crime and he could be pronounced guilty for the purpose. Mind you, strict liability offences are also there, in which means the requirement of mens rea is not necessary, and State of Maharashtra versus Mayor Hans George is one case in point which we will be discussing in the further course of the class. Thank you.